Добрый день, уважаемые участники конференции. С учетом работы переводчика.
Good afternoon, dear participants of this conference, ladies and gentlemen. Considering that we have interpreters who have to interpret everything we say, I do call upon all the rapporteurs to be concise, to stick to legitimate legal terminology, especially since this will be a legal session, and any of the panelists will be able to present their keynotes, the points, the main points of their report within 1 week to the chair of international law of MGIMO, whether in Russian or in English. Even if you do not manage to present your presentation, your report here at the conference, you can still submit your keynotes. It will be published in the International Law magazine in Russian, which is published here, or it will be published in Science Diplomacy, published by the Fletcher School.
So the English variants of your speeches will be published in English. Мы приступаем к работе 7-10 минут, в рамках дискуссии 5 минут.
So we are beginning our session. The time rule is 5 to 10 minutes, 7 to 10 minutes, and 5 minutes for discussion. We will be talking mainly about competing interpretation of international law, respectively in Russia and the US, speaking of the most relevant developments and events in recent years, primarily in Ukraine, starting from 2014, and of course in Syria, starting from 2011. None of us needs to reiterate what's been happening in either of those two countries, Syria or Ukraine, because we all truly know what's been going on. Some of the points, some of those articles on that issue have been published in the Russian magazine on international law, and also in a book of memoirs by Mr. Nikolai Azarov, former Prime Minister of Ukraine in the Viktor Yanukovych government. He essentially tells a very detailed story, a very detailed account of the coup d'etat in Ukraine in February 2014. International legal assessments and interpretations of those events in Ukraine differ very much. They're actually counterposed between Russia and the West. As you know, in Russia essentially accuses the US of violating its obligations under the UN Charter, which, as you know, is considered the main international legal document. Specifically, the principles of the right of nations to self-determination, and secondly, the principle of non-interference in the internal affairs of states. Those are two principles laid out in the UN Charter, which Russia believes the US has violated in its stance in Ukraine. The US position is absolutely different. In the US, they believe, they just ignore the fact that Yanukovych, who was a democratically elected president, was unseated and replaced with Turchinov, who was appointed, not elected. And immediately they point to the fact that Russia annexed Crimea, which belonged to Ukraine according to international documents, which is also true. We don't deny the existence of those documents. So we invite experts to speak their mind on these issues, on these conflicting interpretations vis-à-vis Ukraine and Syria, where assessments also differ, and the issue of whether Russia's involvement is legitimate or not, whether the U.S. involvement in Syria is legitimate or not. We also know that the views there are conflicting. I am very pleased to give the floor to the President of the Russian Association of International Law, Mr. Anatoly KAPUSTIN. Thank you very much, Mr. VYLEGZHANIN. Dear colleagues, before we get down to practical issues regarding the difference in interpreting and evaluating those events and developments, I would like to sort of step aside and step back and say that we're living in a very complex, complicated, difficult time. I see younger faces here, students. They probably don't remember the times when our generations were growing up back in the 70s and the 80s and some of us in the 90s. But I can tell you that once the Cold War was over, back in the 90s, both in Russia and in the West, there were some idealistic assessments and conclusions made, overly optimistic for no reason, overly optimistic about things that we shared, that brought us together, and about our prospects. I remember back in 1992, in our association, Russian Association of International Law, we had then renowned and authoritative experts on law who spoke, and they said that the end of the totalitarian era will provide favorable conditions for global development and the promotion of democracy worldwide. In the West, similarly, there was this concept of the end of history. You all surely know it. That now that all countries are democratic, there will be no conflicts in the world. The countries will have nothing to fight over. But now the page has been turned, and we see that conflicts still linger. Different interests, conflicting opinions, conflicting assessments still exist. And when we speak about conflicting interpretations in the world of the international developments that we are seeing, now I'm a scholar, I'm not a diplomat, I'm not a politician, so I'm not going to touch upon political aspects. I will lay out my outlook as a legal scholar. The problem, of course, primarily is that we have different backgrounds between Russia and the US. That concerns education and background largely. I've been to the US, I've been to US law schools, I've seen how they teach law. I've also spent over 30 years teaching law in Russian schools in various forms and formats and modalities. But in the past, there's always been this unifying idea, this shared idea, that that international law is A, necessary, and B, it has rules that no one should depart from under any conditions, that no one should disregard under any conditions, in any circumstances. There was this understanding both in Russia and in the US. Russian legal scholars, Russian international scholars, and I hope Russian diplomats depart from the fact or base their work on the fact that there's a number of international principles that must be seen as underlying principles and must be always respected, and that is respect for self-determination, abstention from meddling, abstention from use of force, and so on. But speaking of these specific events in Ukraine, what Mr. VYLEGZHANIN spoke about, the events of December 2013 through March 2014. Now, Russian legal scholars and international experts, international affairs experts, they all agree. They have no disagreements about the fact that this was a coup d'etat. This was a constitutional regime, an unconstitutional regime change, and any such change actually is a breach on the rights of the people to self-determination. And recently there was a session in Geneva where I laid out my opinion and my opinion on the concept of revolutions and what they are and how they are seen vis-à-vis international law. There have been both positive and negative examples of revolutions in history, and history eventually will decide about the revolution in Ukraine, whether it was a good thing or a bad thing. But one thing is clear already. That is that those events in Ukraine were taking place right across the border from Russia, because we're neighbors, so in exact vicinity of Russia, and B, those developments in Ukraine were a danger, were a threat to our compatriots, to fellow Russian speakers and there is a very big Russian-speaking population in Ukraine. Now, they are our neighbors, our relatives, they are our family members, there are very strong ties, very strong connections. There was also this remaining issue of Crimea, even though people in Ukraine and in the West are saying now that as of 2014 the Crimea issue had been resolved entirely. We have a different opinion, and we actually we have these two points to make. That is that back in 1991 Ukraine peacefully annexed Crimea from Russia, de facto, not legally. I actually prepared an article on this in 2015. It was published in the magazine of International Comparative Law by the Heidelberg University. So I won't go into detail now, because I went into detail in that article and disclosing my sources. So our point is that the referendum in Crimea in 1991, it was recognized by Ukraine and by the Soviet Union, but not by Russia. It was enough from the Presidium of the Supreme Council that Crimea was part of Russia, and Ukraine actually recognized that. Secondly, the authorities in Crimea who acted based upon the constitution of Crimea as of 1991, they were disbanded, and the new constitution was quickly adopted. Nobody asked the people in Crimea, and actually, the results of the Crimea referendum of 1991, no one ever denied them or rejected them. So you can't actually cancel the results of a referendum. So we believe that the referendum in Crimea in 1991 was legitimate, and its decisions are still effectively in force. So through the declaration of the principles and the Helsinki Final Act and the documents adopted within the framework of the UN and the OSCE, the Organization for Security and Cooperation in Europe, I won't go into detail, but like I said, I laid out those points at the conference in Washington.
The same goes for the self-determination rights. It all begs questions. Sometimes there's no clarity, but as for Crimea, we have met all the necessary requirements for the population of Crimea to be able to implement the self-determination rights. So the acts of Russia are based on the results of the referendum, and it is logical, not only according to our constitution, Constitution, but also based on the international law and principles of self-determination of peoples and the respect for the rights of peoples and principles that enshrine the status of peoples within the international law. As for Syria, just a couple of words on it, because there are also quite a few questions and many discussions involved. At the beginning of May, there was another session of the International Commission on Law, and I'm a member of this council, and it was declared solemnly there that the work of the Committee on the Use of Force in International Laws was finished, and it was declared that there will be a new committee engaged in the issues of rendering military help. So the use of force and rendering military help are two different things. Nevertheless, the shift of focus shows that today the international law science is on the track of progress, and based on the international law field that doesn't have enough evidence, it tries to give recommendations. Again, as for Syria, the situation is not a regular one. For lawyers, what's important is that there's a UN charter, and the Russian Federation was also for the commitment to the UN charter, which is the basis to solve any conflicts. And we know that there are bodies in the UN that are in charge of various things, and Russia based its actions in Syria not only on the agreement that we have with the legal government of Syria. Whatever your approach towards the Syrian government is still efficient, and it is legal in Syria, and it takes control over the majority of the country, and any actions of Russia in accord with the Russian government are deemed legal, and they comply with the main international law principles. As for the future of Syria and of the Russian-US relations, I think that from the point of view of the UN Charter, we need to search for peaceful ways out for the settlement mechanisms of internal conflicts that have already been elaborated, and they comply with the cutting-edge visions of the various conflict settlements. And our opinion of the unsanctioned, unauthorized use of force show that. I mean here the example of the US and France and Great Britain and their actions in Syria against the facilities that have allegedly produced chemical weapons, but these are not valid arguments, not well-founded, and they've just aggravated and exacerbated the situation. Everyone understands that you can accuse any person of anything, and in order to take any legal actions, for them to be legal, we have the UN Charter, and you need to show evidence, and there was no evidence. That is why we are categorically against those actions, and we think that we need to try to find peaceful ways out. And thus I'm finishing and giving the floor to my colleagues. Thank you for your attention. Anatoly Yakovlevich, thank you for your remarks. We agreed that questions to all three speakers would be taken later.
From Fletcher School of Law and Diplomacy, Tufts University. In fact, Professor Trechman is widely cited in Russian literature on international law, especially Russian literature on international economic law. And we are really honored to greet you here. Professor Trechman, please.
Thank you very much, Professor VYLEGZHANIN. It's an honor for me to be here at MGIMO and to discuss these issues of international law and politics. And I think that at the Fletcher School, we recognize that the best way to understand international law is in the political context in which it exists, and we're pleased to be here at MGIMO where the same idea seems to prevail. I have not prepared specific discussions of Ukraine or Syria. Instead, I've prepared a response to the general questions that you see in the program. And my focus is on politics and sovereignty and rules of international law. And the question in the program, and the one that Professor VYLEGZHANIN started with, and Professor KAPUSTIN continued with, is different perceptions of international law. And that idea starts out being strange to me. In my mind, law should be unitary. There should not be different international laws. That would be inconsistent with the rule of law, with the very idea of international law. And yet, as many of us know, there's a new book by Anthea Roberts asking the question, is international law international? And she points out that there are different ways of understanding international law. And there is the book. Thank you. There are different ways of learning international law and understanding international law. That idea of Professor Roberts is actually quite foreign to me as a specialist in international trade law, as a specialist in an area of law where we have a binding treaty with specific rules which are subject to binding mandatory dispute settlement so that differences of view as to the interpretation of that law can be multilaterally resolved. And so I wanted to say that this idea of different views of international law is dependent on a certain vagueness of international law, which I think is endemic in customary international law more than in treaty law. And it's also dependent on not having a binding system of definitive dispute settlement. And in that sense, for powerful states, the idea that there are different international laws is a tool of power. It's a tool of saying that my position is right and I can simply assert it without really recognizing that there may be a more objective understanding of international law. So, in the United States, one of the things that I had trouble with in trying to describe the United States position is that there is no uniform United States position on most of these issues that we discuss. There are many different views among different scholars and political actors, especially about ideas like the use of force. And one of the things about customary international law that maybe is strange is that as customary international law changes, the first time that it changes is often a violation of the customary international law rule that preceded. And so when the United States bombed Kosovo, the international law scholar Anne-Marie Slaughter said, yes, it's not legal, but it might be legitimate. And I think we can understand her suggestion as a suggestion that there might have been an emerging rule of international law, an emerging rule of international law along the lines, perhaps, of the right to protect or humanitarian intervention, which may be part of what Professor KAPUSTIN was speaking of when he spoke of intervention to protect Russian nationals in Crimea, or people of Russian ethnic origin in Crimea, I should say. So, in my mind, the United States government should have a consistent position from administration to administration, at least, although that's not always true. The United States government tends to be relatively positivist focusing on international law in treaties and customary international law that is more or less identifiable, although there are always differences of view as to what constitutes the evidence for particular rules of international law. In my judgment, others may differ, the United States is relatively compliant with its international law obligations, but it's true that the United States is an exceptionalist state that has refused to accept certain rules of international law. For example, in the International Criminal Court, in the Convention on the Law of the Sea, for example. So at Fletcher, we teach international law in social scientific context. The gold standard for us is to try to examine the behavioral effects of international law, to try to see when does it change states' behavior. And that's when it's valuable, when it changes states' behavior. And from that perspective, I think it's important to say that international law begins to fail and begins to be unsatisfactory when it departs too much from the existing political context, from the existing power structure and the desires of states, and especially, let's be frank, the desires of powerful states. So, in connection with the use of force, it may be that international law is not reflecting the political structure of the world, where it denies the possibility for humanitarian intervention. Now, I recognize, and it's important to say, that one person's humanitarian intervention is another person's aggression. And so we have problems of definition, but we also have a need to intervene in horrible crises like Syria. And so that's an existing uncertainty and an existing problem that needs to be resolved. In my own area of specialization, the World Trade Organization and international trade law, I think when China entered the World Trade Organization in 2001, there was an anticipation that China would change, would liberalize in such a way as to make the existing WTO rules fit well with China's behavior. And that liberalization of China's economy didn't occur, and I think that's one of the reasons we see the great difficulties today, that the WTO treaty doesn't fit well for the political relationship between my country, the United States, and China. Another word about the political context of international law. I've always found the idea of sovereign equality a strange idea, because, of course, if you compare the population of China with the population of Monaco, you would say that sovereign equality means grave inequality in the ability of individuals to be represented. So we must mean something more limited than sovereign equality as a whole when we speak of those issues. And so one question is, does sovereign equality reflect well the political realities that exist, the power balances that exist? Let me turn to this principle of non-interference. And here, I think, as Professor VYLEGZHANIN said earlier, we need to use words precisely. And I have to say, I don't like the term principle. I focus on law, and I'm interested in legal rules, and legal rules are different from principles. And so the question is, how is the principle of non-interference instantiated in actual law? Where do we see it in actual law? And what I would say is that with globalization and with increasing technology, it's much more difficult to define rules of non-interference because we're so much integrated technologically and economically that everything we do here in Russia has some effect in other countries. And to say that there's a rule of non-interference is inconsistent with the facts that what we do affects other countries. And so the real question is which particular things are violations of law and which are not. So Australia, in the nuclear test case, argued that the nuclear fallout that came from the French nuclear tests was a violation of Australia's sovereignty. To me, the use of the term sovereignty and the argument from sovereignty is too general. We need more specific rules about what states can and cannot do. They might come from concerns about interference, but not every interference is a violation of international law. Let me express it in the context of the subject for our next panel, which is cybersecurity. You know that in connection with NATO's efforts to define some rules about cybersecurity, they prepared the Tallinn Manual, and they had a group of international law experts say what they thought international law was in the context of cybersecurity issues. And there, I think, they thought that sovereignty was a rule, but the question, once you take it as a rule, is what is its content? What does it mean? And I start with general international law, with the Lotus case from 1927, the rule that states are not permitted to exercise power in the territory of another state. And we have other articulations in the Nicaragua case against the United States, where coercive action that has effects in another state on its governmental functions seems to be a violation of international law. So the question I would ask is, what does sovereignty tell us? What kinds of questions does it answer? There's uncertainty, actually, as to whether espionage is a violation of international law. We might consider some types of cyber attack as similar to espionage or equal to a type of espionage. But is cyber intrusion a violation of international law? Was the hacking of the Democratic National Committee a violation of international law or not? The Tallinn Manual in Rule 4 says, and I'm quoting, cyber operations that prevent or disregard another state's exercise of its sovereign prerogatives constitute a violation of such sovereignty and are prohibited by international law. So it's equating sovereignty with attacks on sovereignty with violation of international law. I just saw that the former United States Director of National Intelligence, James Clapper, said that in the 2016 elections, Russian hacking changed the outcome of the election, shifting 80,000 votes in 3 states. So you might ask the question, under that Tallinn Manual rule or in other rules of non-interference, and I know we disagree on these facts, but assuming the facts that Clapper states were true, would that be a violation of international law? In the second Tallinn Manual, Tallinn Manual 2, they said you should look to the degree of infringement upon the target state's territorial sovereignty. There's that word again. And whether there's been an interference with or usurpation of inherently governmental functions. And so that might give us a start, but I would ask for more specific rules. I think we need more specific rules to deal with the technological challenges of greater integration because of the Internet, because of cyber integration. So it's true that not all intrusions are illegal. We can speak about a question of what is sovereignty. Is outer space? This is something that we were discussing yesterday. Where does outer space become outside the sovereignty of a state? What are the borders of a state? And do we need to focus on territorial integrity, or is there something more to think about? So I think in this area of cybersecurity, and in really all of these areas, including a right to protect or humanitarian intervention or any of these things, we need to begin to develop more specific rules and avoid trying to answer questions with these very general ideas of sovereignty and non-interference. So this is a call to avoid answering questions through assertions to customary international law, which often takes too much time to develop, has trouble responding to new technologies, new integration, and try to evaluate how we can write new treaties to address with more specificity our concerns. Let me stop there. Thank you.
Следующий участник нашей дискуссии.
The next participant of our discussion, Professor of the International Law Department, Mikhail Lysenko, Ambassador Extraordinary and Plenipotentiary. Thank you, dear moderator, dear guests and participants of the conference. The topic of our session is competing interpretations of international law. It is, in fact, relevant, and the search of the legal truth through the professional discussion, constructive discussions, the clash of opinions, it is a normal and healthy process, but only if it is aimed at the strengthening of international law and at finding consensus. Unfortunately, on the example of foreign military intervention in Syria, we see the contrary. We see attempts to totally ignore international law when it becomes an obstacle, or to act based on the rule of force. I'll remind what is known to everyone. In international law, in the UN Charter, there are only two legal ways to use military force: based on the UNSC decisions or for self-defense, individual or collective self-defense. Russia uses force, military force in Syria based on the collective self-defense in response to the request of the legal government of Syria, and it is enshrined in bilateral interparliamentary agreements with Syria. And what is the reason for the US and its allies to bomb Syria, to deliver airstrikes? Who has invited them? The legal government has not invited them. Based on which resolution of the UN Security Council do they fight there? There's no such resolution. It is no accident that the mass missile strike against Syria on the 14th of April of this year, when more than 100 missiles were launched, it was condemned in particular by the Permanent Council of the Collective Security Treaty Organization. This organization unites allies of Russia in the CIS. The Permanent Council assessed this as a violation of fundamental principles and norms of international law, contrary to the UN Charter and without the UN Security Council sanction. Russia expressed assessed it in a more categorical way. It called it an act of aggression. What's concerning us? The US and its allies used to try to fit into any, even most general decisions of the SC of the United Nations to justify its military actions. This was the case when the West used military force in Iraq, former Yugoslavia and Libya. But we do not see that now. They've launched 100 missiles against Syria, but at the UNSC, no one ever had such a decision. They wouldn't need the UNSC for this. And this is what the US permanent representative in the UN, Ms. Haley, said, the UN Security Council exploited all its justifications, and the US perhaps would have to ask Pentagon to sort out the North Korean nuclear program issue. Another quote of the current Council of the US President on National Security, Mr. Bolton. The US has to declare as its goal the change of power in Iran of the Ayatollah regime. The behavior of the Iranian regime is not to be changed, so we need to change the regime itself. Now it's clear why the US, in addition to Syria, has taken a number of steps that challenge international law. Among them, the withdrawal from the Paris Climate Agreement and UNESCO, and they admit that Jerusalem is the capital of Israel, bypassing the UNSC decisions. US withdraws from the Iranian nuclear deal, and at the same time it threats sanctions to its own allies. It is no surprise that Russia, as a state that respects its own sovereignty and international law, is not accepting such an approach. So where are we heading? What are we supposed to do? Are we heading towards confrontation? How can we stabilize international relations? I think that now we need to do everything that's possible to restore, in the first place, the full-fledged dialogue on all the platforms. Here's a specific example of what we could have done. I'll remind you that in November 2017, Presidents Putin and Trump met in Vietnam at the margins of the annual Asia-Pacific Economic Community Summit. The two presidents issued a joint statement on Syria. For some reason, there are not so many people who quote this document, although it is very important. Here are some quotes from this document. The presidents confirmed their determination to defeat ISIS. They agreed to support military channels of communication between military professionals to help ensure the safety of both US and Russian forces, and de-confliction, affirmed to their commitment to Syria's sovereignty, unity, independence, territorial integrity, and secular character of Syria, and so on and so forth. This was a large document, and I don't have enough time to quote the whole document. But as we see, this paper agreed on the most important principles and ways to achieve peace in Syria. I think that we could have seen this symbolic, important document that was forgotten for some reason through the new reality. We could have discussed it and strengthened the document through constructive ideas. We could have added things that were enshrined in the basic resolution of the UNSC Resolution 2254 on Syria. And then we could have considered it in the UNSC in order to adopt a consensus resolution. This is a practical step that we could have taken, but there's a number of other creative options where we could have achieved agreements on other political issues. What we need here is the political will. And to conclude, I'll reiterate that the key to find the way out of this difficult situation is the professional discussion and respect for international law. And I support the idea that has been expressed here by my colleague, Professor Trenchman, if I understood it right, that
Международное право должно быть всеобщим.
Уверен, что свой вклад в общее дело внесет.
And I'm sure that our discussions, our deliberations here will also make their contribution. Thank you.
Dear colleagues, the floor is open for questions. you might ask your questions in English or in Russian. You might indicate the speaker to whom the question is addressed or not. Up to you. Questions, please. Yes.
I will make a comment, and then I will address my question to Professor, is it Trachtman or maybe Trachtman? Forgive me. You can hear from my voice that I'm English, or hopefully so. So therefore, I'm speaking to two sets of friends. My Russian friends, because I live and work here, including at this university, and of course being British, to my American friends, you know that we're good friends of each other. I would like to make a comment on Ukraine, and then I will ask for Professor Trachtman's response. Law, let alone international law, at the best of times is difficult. That's why we have court cases, amongst other things. It's hard to reconcile, surely, territorial integrity with the self-determination of peoples. Of course, other areas of law, municipal law, including sometimes constitutional law, play an important factor, direct or sometimes indirect, in international law. Part of the concern, disappointment on this side here in Russia towards the Ukraine issue, and I address this to all my American friends, is because in 1954, when Crimea, was transferred from Russia to Ukraine within the Soviet Union, it was done unconstitutionally, in violation of the 1936 Soviet Constitution, which was then in force. Equally, 4 years ago, when the events that occurred in Kiev happened, that was also done in violation of the 1996 Ukrainian Constitution that was then in force. I've studied it. It was. Indeed, that's why the recent events in Armenia, constitutionalism was so important there. Nevertheless, I acknowledge the Budapest Memorandum of 1994 and what that provided for, and also the Treaty of Friendship of 1997 between Ukraine and Russia and what that provided for. But will Professor Trachtman perhaps acknowledge that law being difficult, that there are sometimes alternative views and interpretations, which therefore I would urge my American friends to pay attention to before they perhaps take such a strident position towards Russia's actions? Would he therefore accept that there are other arguments on the other side, whether perhaps they're ones that he shares or not, in light of what I said? Forgive me if I went on too long.
Thank you for that thoughtful and challenging question. It's not an area that I've studied closely, so I really hesitate to say much about it. It's true, as you say, that there are always different interpretations of law, and words have a great deal of flexibility, but I would not feel comfortable being a lawyer if I didn't think that there were better meanings and worse meanings, better arguments about meaning and worse arguments about meaning. And so I think that it's possible to say that there is some determinacy in law. What I was suggesting is that there is insufficient determinacy today in the laws, the so-called laws, maybe we should call them principles of sovereignty, of self-determination, of non-interference. And my argument was a plea in important areas like cybersecurity for more specific rules, and also perhaps for multilateral determination of the meaning of those rules in order to make them effective. And I think that that kind of mechanism can enhance the predictability and reliability and make it less subject to the exercise of raw power in connection with these kinds of issues. And so I think that the debate about Ukraine and Crimea is an illustration of my point that the international legal system, and I think this is your point as well, that the international legal system doesn't yet provide a solid enough way for us to predict what will be legal and illegal. But having said that, I think that there are better arguments and worse arguments. They sound in the area of diplomatic discourse until we have adjudication and more reliable ways to apply them.
Thank you. Just one probably short reference. In fact, the consequences of transfer the Crimea from the Russian Soviet Socialist Republic to the Ukrainian Soviet Socialist Republic in 1954 did not have any consequences from the point of international law. It has consequences from the point of national law. But as for international law, no consequences at all, because the territorial sea around Crimea, it is territorial sea of the Soviet Union. All the military power, again, in Moscow. So no consequences regarding to sovereignty. It's just a matter, I would say, of economic consequences, not more. Any questions? Yes, please. Yeah. Young generation, of course.
Yes, I would like to address my question to Professor Frenchman.
Yeah.
Thank you. I'm a postgraduate student of the International Law Department. Mm-hmm. My name is Nikita Stamen. And I would like you, before addressing the question, I would like to cite former U.S. Vice President Joe Biden and his recent, what he wrote in his recent book, that he made the last of many urgent calls to Yanukovych in late February of 2014, warned him for months to exercise restraint in dealing with citizens, and, well, the final phrase which he told to President Yanukovych was to call off the gunmen and to walk away. So my question will have more practical dimension. Do you regard personally that such call, such expression from vice president of one state to another president, to the president of another state, to walk away, to call off the law enforcement from the streets, could you regard such telephone call as an interference to the domestic into the domestic jurisdiction of the state? Mm-hmm. And also, what would be if, for example, our vice president or the director of the Federal Security Service called the president of the United States with the same formulations, with the same, let's say, desires, or desires and demands. Thank you.
Yes, I'm sure that Professor Treshman will be glad to answer you. Just one note. According to the Russian Constitution, we do not have position vice president. Yes, please.
Again, this is not my area of expertise, but I think it's clear that saying things to people, making suggestions to people, even speaking to NGOs or others in another state is not a violation of any international law. It may be, and this is part of the uncertainty of this idea of non-interference. You might say, you're interfering in my politics, and it may be a bad idea It may be bad policy, but to simply say, here's my advice to you, how could that be a violation of international law?
Okay. Well.
Thank you. My question will be addressed also to Professor Trackman. My name is Alexei Kudrin. I'm also the postgraduate student of MGIMO University, and thank you very much for your speech. And I wonder if you could comment the reasons that international law is still not unitary, and there are some misunderstanding and different competing interpretations of rules and principles of international law. What are the reasons of this difference? Not maybe they lies in the political sphere. Maybe they are connected with the uncertainty of factual circumstances, because sometimes we do not know to whom we can believe. And I may also cite the speech of Prime Minister of Ukraine, Azarov, who spoke that there was an interference in the internal matters of the state of Ukraine, and that there are some instructions which were addressed to the protesters of the oppositioners from the United States Embassy. And how can we formulate and make some international law qualifications when the facts are uncertain? And this is my question. A question about the reasons of different international law qualifications. Thank you.
Thank you for that excellent question. And I do want to invite my colleague, Professor Lysenko, to comment on all of these things. I don't want to dominate the discussion. It's a very interesting question. Why is it not unitary? I would say, to the extent it is indeed international law, we have this idea that there could be regional custom, but let's ignore that. To the extent that it's really international law, it is unitary. What's not unitary, as we've said, is the interpretation of what it requires. So it's unitary in a void somewhere, but we don't know what it is. And so what would make it non-unitary, and I can give you the example from the area that I study, trade law, what makes it non-unitary is a specific rule in the international agreement that the interpretation of the international agreement will be assigned to a tribunal, to a panel, and then to the WTO appellate body. And that makes the understanding of what the law requires unitary. Now, your question is very interesting. Why haven't we done that in other areas? And, you know, I have a social scientific approach to these things. My question is, what are the effects of international law? And in response to your question, what are the causes of international law? What causes greater specificity and mandatory dispute settlement in trade law, but not in the laws about the use of force? And I think it's a matter of the desires of powerful states to retain a certain amount of flexibility. In other areas, it may be that it hasn't yet seemed worthwhile to establish those kinds of institutional responses. But I think your last point is also an excellent point, that when we discuss questions about the United States elections and questions about Ukraine, a lot of these questions have to do with facts. And I'm very interested in that in the area of cybersecurity and cyber attacks. And there, it's a question of attribution. Unlike with missiles and other kinds of weapons, it's very difficult to know who is making the attack. And I think there we need greater accessibility to facts and greater shared facts, greater unitary facts. So in the project that I'm working on with a number of other scholars, including computer scientists, is to try to identify whether it would be possible to form an international organization that would be responsible for attribution that could be reliable and, in that sense, unitary, so that we could say, now we know where the attack originated, and we all agree that that's a definitive statement.
Professor Lysenko, would you like to add?
Да, спасибо. Дискуссия наша показывает, что название сессии «Конкурирующие интерпретации международного права» попало в самую точку. Ну что же, технологии, жизнь очень часто опережает международное право. Посмотрим на космические технологии, ядерные, кибертехнологии. Действительно, есть много областей, где ядерное право даже еще и не сделало первых шагов, чтобы как-то регламентировать, регулировать эти вопросы. Ну, например, в сфере космоса кто мог подумать, что будет такая проблема, как космический мусор? И до сих пор нет конвенций, которые бы регулировали эти вопросы. Есть свод правил, деклараций, принципов и так далее. Но конвенций нет до сих пор. Ну, таких примеров можно привести массу. Но тем не менее, надо исходить из того, что должны, и в большинстве случаев есть какие-то базовые истины. Они в нашем случае называются принципы международного права, может быть, не совсем даже и удачное название, но тем не менее, есть базовые вещи, как в Библии есть 10 заповедей, которые были выработаны веками назад. По ним можно спорить, жизнь тоже их опережает, но они есть. Также и в международном праве есть известные принципы, общепризнанные принципы международного права. Но работать над их уточнением, совершенствованием, безусловно, надо. И этим должна заниматься комиссия ООН по международному праву. Самый известный для всех позитивный результат – это Конвенция по морскому праву, которая выработала такой оптимальный передовой кодекс, так сказать, правовой.
Николаевич, это следующая сессия с 15 часов Common Spaces.
Понятно. Хорошо. Ну и здесь касались вопроса Украины. Я бы сказал, что по Украине не надо забывать один принципиально важный момент в цепочке правовых последствий и событий. Крым провозгласил себя независимым государством, которое получило название Республика Крым. И уже в этом качестве Крым, независимое одно государство, и второе государство России подписали межгосударственный договор, согласно которому Крым по тексту этого договора добровольно вошел в состав России. Поэтому все разговоры об аннексии, они нелегитимны, потому что была не аннексия, а был договор двух независимых государств. Спасибо.
Спасибо. Так, пожалуйста.
Уважаемый Александр Николаевич, уважаемые коллеги, добрый день. I will speak in Russian. Профессору Тречману вопрос. Вы говорили о том, что необходимо исследовать право и международное право.
Dear colleagues, I'll be speaking Russian. You said that we need to use law in a political context. This will give us an understanding of the measures, of the actions taken by governments. What we are seeing today is that the U.S., in its foreign trade and its foreign economic activities, justify their actions with the need to ensure national security. So my question is the following. Doesn't the political context of U.S. foreign trade and foreign economic activity create a danger to the global trade architecture and to the global trade regime?
In our constitutional structure, the power over commerce lies with our Congress. But our Congress, through statute, delegates authority to the President. And there is a provision, rather vague, that gives the President national security-based authority to take action. And this is what he's done in connection with steel and aluminum. And in my mind, the predicate, so the President has given great deference in our courts over judgments under these statutes, but in my mind, this exceeds that deference, and I hope that there will be an internal legal attack on that particular action. In the WTO, the United States will defend that particular set of actions on steel and aluminum as being eligible for the exception under Article 21 of GATT for, it's a long phrase, but national security. And I think if you look at the specific words, and they're not as clear as they should be, it's likely that the United States action is not authorized under that national security exception. But the United States, and this is an area where we don't have unitary international law in the WTO system, because the United States has consistently taken the position that that provision is self-judging and not subject to dispute settlement. So it's a gap in that unitary system. In connection with the United States' unilateral actions against China about intellectual property, which have in part a national security motivation, I think those two are illegal under international law, and they violate a very interesting provision of the WTO treaty that says when you have a problem with an issue under WTO law, you must bring that problem to the multilateral system. You may not operate unilaterally. So I think that's a violation of that too. And I think it's up to China, Russia, the European Union, other trade partners to uphold the system during what I hope will be a temporary problem in the United States' compliance with international trade law.
Thank you. Yes.
Hi, my question is prompted by Professor Lysenko's. My question is prompted by his comments on Syria, and I'm not a lawyer, so forgive me if this is a naive question. But are there legal circumstances under which a legitimate government delegitimizes itself by humanitarian violations against its own population? And if so, can that justify other external interventions or perhaps invalidate invited interventions by that government?
Спасибо. Я сторонник того, чтобы...
Thank you for this question. Personally, I am in favor, I believe that any action should be taken based on international law. Humanitarian intervention has been mentioned here, and there was a question of whether it can be legitimate or justified. I believe a humanitarian intervention can be justified, may be justified, but only in case it has been authorized by a UN Security Council mandate or resolution. Which specifies, the time frame and everything. When there is no such mandate from the UN Security Council, any attempt by one country or government to punish or somehow put to right another government is illegitimate, is illegal. You cannot deliver airstrikes on another country without getting a permission, an authorization from the UN Security Council. Somebody may say, but a certain permanent member, such as Russia, can always veto such resolutions in the UN Security Council, or vice versa. Russia may be pressing for action, and the US may block that, may veto that. But that actually means that we haven't exhausted all the opportunities to study this area in depth and objectively to come up with a response, whether a sitting government can really delegitimize itself, and whether there actually were atrocities committed by government troops in a given country. For example, the recent airstrikes in Syria were delivered based on the premise that the Syrian government had performed a chemical attack, a gas attack against its own population in Duma. But later it was disproved as a fake, and actually airstrikes were delivered against Syrian installations before OECP, the Organization for the Control of Chemical Weapons, for the Prohibition of Chemical Weapons, OPCW, before its inspectors had the time to arrive in Syria to investigate. Thank you.
My name is Dmitry Labin. I'm professor of international law. I'm sorry to bother Professor Trachtman because I know my colleagues very well, but I'm going to ask you maybe a comfortable question. We just discussed some controversy in international law, and shortly, could you please explain us the position of the United States towards the comprehensive agreement in economic sphere? I'm talking about the Trans-Pacific partnership. As far as we know, the former administration made a lot of efforts in order to create the agreement and to make it. But the administration of the current president decided that was wrong. What is wrong?
Nothing. So you're quite correct that the Trans-Pacific Partnership was negotiated over a number of years, with the United States taking a leading role in the negotiations, and the idea was to create what they called a 21st century trade agreement that would address a number of the gaps in earlier free trade agreements, and also would include provisions that would solve some of these problems that I referenced earlier about China's compliance with the kinds of rules that the United States and maybe other states would like to see China comply with. Even though China was not going to be a member, the thought was once we establish the Trans-Pacific Partnership, we might induce China to join, and then those rules, those additional rules on state-owned enterprises and other important issues would become applicable to China. So I think President Trump, on the campaign trail before he became president, expressed a populist view that United States workers were excessively hurt by trade liberalization. It's false. Some workers are hurt, but many workers are helped and many consumers are helped. And then, of course, and China actually benefited from this when it entered into the WTO. Once you liberalize imports, it makes your state a more efficient producer of all sorts of goods because the components with long supply chains become cheaper. And so I think it was a serious error to back away from the Trans-Pacific Partnership for purely economic reasons. Some people thought it was also an error from geopolitical purposes. And I only hope that at some point that error will be remedied. I would note that as the United States has sought to renegotiate the North American Free Trade Agreement, we've been looking at the Trans-Pacific Partnership and saying those kinds of provisions are actually the kinds of provisions that we would like to see in that agreement. So President Trump, I think, rejected the expertise and the loyalty of the bureaucrats, of the people in our trade ministry and the United States Trade Representative who worked on that agreement, and I think that was a mistake.